The clock is ticking, not just on a presidency, but on a man's freedom. For years, the narrative has been a simple one. As long as Donald Trump holds the highest office in the land, he is untouchable, a fortress protected by the ultimate political armor. But a seismic shift has occurred. The shield is gone. The armor has been stripped away, and the legal machinery that has been circling for years is now closing in, its gears grinding with a terrifying finality. The central question that has dominated American politics since he left the White House has now mutated into something far more urgent, far more personal, and infinitely more dangerous. It is no longer just about policy or legacy or political revenge. It is about survival. The unprecedented reality now facing the former president is a brutal equation that has gripped the nation and the world. If he does not win the coming election, the courtroom is waiting. And not just any courtroom, but a series of them. Each one a potential trapdoor into a future he has spent his entire life trying to avoid. This is the story of a man fighting a two-front war. One front is the battle for the White House, a campaign of rallies, rhetoric, and political warfare. The other front is the battle for his liberty, a high-stakes legal war where the ammunition is indictments, the strategy is delay, and the ultimate prize is simply staying out of an orange jumpsuit. This is not a hypothetical scenario from a political thriller. This is the cold, hard reality of the post-presidency landscape in 2026. The central event that has crystallized this existential crisis is the culmination of 4 major criminal investigations that have now converged into a single, unavoidable path to trial. The Department of Justice, under a special counsel whose mandate has outlasted the administration that appointed him, has finalized its case. The indictments are no longer speculative. They are filed. The charges, ranging from the mishandling of classified documents at Mar-a-Lago to the alleged conspiracy to overturn the 2020 election, are not mere allegations on paper. They represent a legal hammer poised to fall. The primary target of this judicial onslaught is not just a former president, but the current frontrunner for the Republican nomination. The event we are analyzing is the unprecedented legal deadline that now looms. Judge Aileen Cannon, once seen as a favorable arbiter in the documents case, has set a trial date that lands squarely in the middle of the primary season. Meanwhile, in Washington, D.C., Judge Tanya Chutkan has signaled her intention to move the election interference case forward with a speed that leaves little room for the traditional legal stalling tactics that have been the defendant's primary strategy. The message from the bench is clear. The law will no longer wait for the political calendar. This convergence of judicial timelines has created a perfect storm, transforming the political contest into a desperate legal defense. The purpose of this analysis is to lay out the precise mechanics of this dual front war, to explain how the courtroom has become the new battlefield, and to explore the terrifyingly simple premise that for one man, losing an election is no longer just a political defeat, it is a potential life. On the other side is the narrative put forward by the defendant and his allies. This claim is one of unprecedented political warfare. They allege that the entire legal apparatus, from the White House to the Department of Justice to the state courthouses in New York and Georgia, has been weaponized against them. The narrative is that this is not a quest for justice, but a coordinated lawfare campaign designed to derail a political campaign. According to this perspective, the timing of the indictments, the selection of the prosecutors, and the jurisdictions in which the cases were filed are all evidence of a deep state conspiracy to prevent Donald Trump from returning to power. They argue that the classified documents case is a dispute over record-keeping blown out of proportion, and that the election interference case is a criminalization of political speech and legal challenges to an election they still claim was stolen. They present the legal battles not as a reckoning for past actions, but as a preemptive strike against a political movement that the establishment fears. The purpose of this counter-narrative is to create a powerful political shield for the defendant, transforming his legal peril into a badge of honor for his supporters, who see the trials not as a judgment of guilt, but as proof that he is the one the system fears the most. The tension between these two narratives creates a volatile environment that extends far beyond the courtroom. For Donald Trump, the strategy has been clear from the beginning. Delay, delay, delay. The political calculation is brutally simple. If he can push all trials past the November election, and if he wins that election, he would return to the White House with the power to fundamentally alter his legal fate. As a sitting president, he could order his new attorney general to dismiss the federal cases. The constitutional questions surrounding a president ordering the dismissal of charges against himself would be unprecedented, but the power would theoretically be his. Furthermore, he could potentially pardon himself for federal crimes, a move with no clear constitutional prohibition, but one that would ignite a firestorm of legal and political challenges. The shield he lost in 2021 would be reforged stronger than ever. This is why the judicial clock is the central battlefield. Every motion to dismiss, every appeal on a procedural issue, every request for a hearing on the scope of presidential immunity is a tool designed to run out the clock. The defense team has become a masterclass in legal obstruction, filing hundreds of pages of motions, challenging the legitimacy of the special counsel's appointment, and appealing every adverse ruling. The goal is not necessarily to win these legal arguments on their merits, but to consume time. The strategy is a high-wire act. It buys time, but it also creates a narrative of a defendant who is fighting the system. The prosecution, aware of this strategy, has been pushing for speed. The appointment of a special counsel was intended to insulate the investigation from political interference and to project an image of impartiality. The prosecutors have argued for expedited trial schedules, noting the public interest in a speedy resolution. They have countered defense motions with arguments about the need for finality and the principle that no defendant, regardless of status, is entitled to delay justice indefinitely. Before we dive into the intricate legal and political maneuvering that is defining this historic moment, this is the kind of in-depth, high-stakes analysis you won't find anywhere else. We cut through the noise to get to the strategic core of the story. If you want to stay ahead of the curve on the most critical geopolitical and political events shaping our world, make sure to hit the like button and subscribe to the channel. Hit the bell icon to turn on notifications so you never miss an update. Because in a news cycle that moves at the speed of light, you need a source that brings you the full picture. Now let's get into the details. To understand the severity of this situation, we have to go back to the foundational principle that has always protected a president. For decades, the Department of Justice operated under a legal opinion that a sitting president could not be indicted. It was a matter of constitutional gravity, the idea that the criminal justice system could not be allowed to incapacitate the chief executive. This unwritten rule provided a legal sanctuary. As long as a president is in power, they are, for all practical purposes, immune from prosecution. This is the shield that Donald Trump wielded throughout his 4 years in the White House. The moment he lost the 2020 election, however, that shield began to fade, and on January 20th, 2021, it vanished entirely. The legal armor was gone, leaving him exposed to a cascade of investigations that had been quietly building in the background. Now, in 2026, the landscape has changed again. Trump is once more a candidate, but he is not yet the president. He exists in a legal limbo, a private citizen with the political power of a frontrunner, but none of the constitutional protections of the office he seeks. This is the context that makes the current moment so explosively dangerous for him. The legal cases are no longer in the investigative phase. They are in the pretrial phase. The Manhattan District Attorney's case, centered on hush money payments, has already concluded with a historic conviction on 34 felony counts, marking the first time a former American president has been found guilty of a crime. That conviction, now under appeal, was just the opening salvo. The real threats are the federal cases. The classified documents case, centered in Florida, is arguably the most cut and dry legally. According to the indictment, hundreds of classified documents were taken from the White House to Mar-a-Lago. Despite months of requests from the National Archives and a grand jury subpoena, many were not returned. Photographs included in the filing show boxes of documents stacked in a ballroom, a bathroom, and a shower. The charges include willful retention of national defense information, a violation of the Espionage Act, and conspiracy to obstruct justice. This is not a case built on complicated political theories. It is a case built on physical evidence, witness testimony, and the actions of the defendant himself. In any other context, a conviction on these charges would carry a significant sentence measured in years. Simultaneously, the election interference case in Washington, D.C. strikes at the very heart of the democratic process. The indictment alleges a sprawling conspiracy to overturn the results of the 2020 election, culminating in the January 6th attack on the Capitol. It details a pressure campaign on state officials, a scheme to put forward fake slates of electors, and the relentless pressure on Vice President Mike Pence to reject the certified electoral votes. This case is not about paper records. It is about the alleged subversion of a fundamental pillar of American governance. The narrative here is one of a president who, according to the government, refused to accept the peaceful transfer of power and instead sought to remain in office through unlawful means. This is where the story fractures into two competing, irreconcilable realities. On one side, you have the narrative presented by the Department of Justice. According to federal prosecutors, this is a straightforward matter of law and order. Their claim is that no individual, not even a former president, is above the law. They present a mountain of evidence, recorded conversations, contemporaneous notes from White House lawyers, testimony from senior aides, and the public statements of the defendant himself. They argue that the indictments are not political persecution, but the result of a grand jury process that found probable cause to believe crimes were committed. Their position is that the judicial process must run its course without regard to the defendant's political ambitions. To them, the fact that he is a candidate is irrelevant to the question of guilt or innocence. The purpose of the justice system, they argue, is to hold individuals accountable for their actions, and these actions, they say, constitute grave offenses against the state. But the strategic analysis must also account for the electoral front. The legal battles are now inextricably linked to the political campaign. Each court appearance is a media event. Each ruling is a data point in the political calculus of voters. The conviction in New York, for instance, had a complex effect. It galvanized his base, resulting in a surge of campaign donations and a consolidation of support among Republican primary voters. Yet, it also gave his general election opponents a potent line of attack that he is a convicted felon. The campaign is no longer just about policy debates on the debate stage, it is about legal arguments at the bench. The candidate's schedule is dictated not by rallies alone, but by court dates. His public statements are scrutinized not just for political messaging, but for potential violations of gag orders. This dual front war has created an unprecedented dynamic in American history. The traditional boundaries between the political and the judicial have been obliterated. We are witnessing the spectacle of a leading presidential candidate spending his days in a courtroom, listening to prosecutors detail evidence against him, while simultaneously holding press conferences on the courthouse steps to frame the proceedings to the electorate. The global implications are staggering. Foreign allies are watching to see if the American political system can withstand this level of internal pressure. Adversaries are probing for weakness, viewing the chaos as an opportunity. The stability of the United States, the world's preeminent military and economic power, is being tested by a scenario the Founding Fathers never could have imagined. A former president facing potential prison time, running to reclaim the office that would make him immune from that very sentence. The suspense is now at its peak. The legal calendar for the coming months is a landmine field. The Supreme Court is weighing the question of presidential immunity, a ruling that could either gut the D.C. case or provide the delay the defense desperately needs. The judge in Florida is setting firm deadlines for pretrial filings. The Georgia election interference case, though stalled by appeals regarding the district attorney's conduct, looms as another potential trial venue. Each decision, each ruling, each hearing is a step closer to a moment of finality. The central character in this drama is moving through a world of narrowing options. His entire life has been defined by finding a way out, by leveraging power to escape consequences. From his days as a real estate developer in New York to the White House, he has always managed to turn legal peril into a story of persecution and emerge, if not unscathed, at least undefeated. But the stakes have never been this high. The power he seeks to reclaim is not just for political ambition, it is quite literally for his freedom. The machinery of the state is grinding forward. The men and women in the courtrooms are not politicians, they are judges, clerks, and jurors who are now being asked to perform their duties in the most politically charged atmosphere in American history. The trial in Manhattan is over, but the appellate process continues. The federal trials have yet to begin, and the election, the ultimate political event, is a ticking clock in the background. What happens when the calendar runs out? What happens if a trial concludes before the election? A guilty verdict in the documents case would mean a sentencing hearing. Would a judge sentence a former president and current candidate to prison? If so, how would a prison sentence interact with a presidential campaign? Could a candidate campaign from a federal facility? These are not academic questions. They are scenarios that legal scholars and campaign strategists are actively gaming out. The country is in uncharted territory, and what if he wins the election while awaiting trial? The constitutional crisis would be immediate and profound. The newly elected president would likely order the dismissal of the federal cases, arguing that the executive branch cannot prosecute its own head of government. This would trigger a legal challenge from the special counsel, who would argue that the principle of no one being above the law must prevail. The Supreme Court would be forced to rule on whether a president can order the termination of a criminal investigation into his own conduct. The potential for a constitutional showdown is immense. The narrative has moved from the abstract to the concrete. The legal consequences are no longer a distant possibility. They are a near certainty if the political shield is not restored. The legal experts are unanimous in their assessment. If Donald Trump is not the president, he will go to trial on these charges. And the evidence in the federal cases, particularly the documents case, is considered by legal analysts to be overwhelming.